Hearing, the First District Court of Appeal is now open. All who have business for this court, draw near to their attention and shall be heard. God save the United States, President before us, and His Honorable.
Please be seated. We have only one case on the calendar this afternoon, or one case remaining on the calendar this afternoon. We've been suffering from a process of attrition for some reason today and tomorrow. We've allotted 15 minutes to decide, and we're ready when you are.
May it please the court, and Victoria Wiggins, counsel for the appellant, please let me know if you can't understand my speech. Thank you. I would like to reserve 5 minutes for rebuttal. The main issue here to argue is whether there was a sufficient connection between the criminal act of a defendant and the harm suffered by the victim. There is undisputed evidence that some type of death took place, no question. But the evidence presented by the state was speculative as to what amount was actually caused by criminal act and what was caused by negligence. Then,
counsel, you would agree that there was evidence before the jury. The weight of it, was not for us to determine, but there was evidence before the jury that about $100,000, in excess of $100,000, was attributable to this cancel and no sale scheme, I guess you'd call it. Would you not?
I will argue that the evidence was full of reasonable doubt because based on cash register tapes that had no identification system and for which cashier was doing what transactions, there was some. They are testified on page 161 of Volume 2 that she alone could not decipher which no sale and cancellation were legitimate and which were not legitimate from the registered tapes. Yes, there was evidence from the detectives about a different sums, but your honors, they never gave the jury evidence of how they came to those numbers. No evidence of how they deciphered who was doing what. They basically said, well, we watched 60 days of videotapes and we came up with maybe it was more, maybe it was 4 hours, but they never gave any concrete evidence as to how they deciphered which transactions were suspicious to justify that evidence. In other words, maybe an analogy would be like when you have a theft of a television and the victim comes in and testifies, well, it was worth $100 or $500 when I bought it. well, this court would say that's not sufficient to establish the value of the stuff. You have to have some proof of where it was bought, the depreciation. Yeah, we have to have that kind of analysis with a physical item. Then when you
Let me
have
ask you this, counsel. With the reconstruction that the detectives did and that Ms. Davis did, and they came up with the $100,000 number, isn't it reasonable for us to look at this verdict that found her guilty, the appellant guilty, of between $20,000 and $100,000, that the jury looked at all that information and took into account everything that you're telling us, that we don't have precise numbers because of the nature of this offense, but they recognized that at least $20,000 was stolen, but perhaps not as much as the $100,000 that was initially charged. Isn't that a reasonable review, observation based upon our record here?
I'll get a matter of public policy, Your Honor. No, because that gives a business owner a license to prosecute an employee of theft without sufficient evidence.
So, Ms. Wiggins, I guess what you're telling us then, if I understand your argument, is if the scheme is complicated enough, there's no way you can ever prosecute it successfully.
Well, no, sir. There was checks and balances in place for the owner to use on a daily basis that she did not use. There are accounting practices that she said that she did not use on a daily basis. She did not check the register tapes, the journal tapes on a daily basis. She went 6 months after the fact and says, "Oh, I think I have a business loss. Let me go back 6 months before and try to figure out what happened." That's why you have accounting procedures so that you can pinpoint who did what. And when we allow business owners to prosecute their employees for grand theft without any real substantial evidence pointing out that this amount of economic loss was directly attributable to a criminal act, then we're opening the doors to allow business owners to prosecute and hope to get back some of the lost profits.
Isn't this case different from the cases you cited us in your brief where they looked at shrinkage and lost profits? I mean, they went back and granted, waited longer than the day after the loss was occurred, but they went back and attempted to reconstruct the best they could with the records that they did have as to specific dollar amounts. This isn't a shrinkage or lost profits case, is it?
Anyway, it's like this. Anyway, it should be cases ambiguous. The analogy here to that, Your Honor, is that again, you're dealing with ambiguous figures. You're dealing with ambiguity. You're not sure who to put. That's why I cited Rich v. State and Springland v. State for a proposition that there has to be a clear nexus between the criminal act of a defendant and the economic harm suffered. And this case you clearly do not have it. You have a lot of speculation. What it may have been one of the three, it may have been another big cashier who did no sale. And just really ambiguous as to who did what because the business owner did not practice her accounting procedures.
Well, you keep talking about accounting procedures. Are we going to ask every mom and pop business in the country to institute the best accounting principles if they're going to try and prosecute somebody for crime?
So, all due respect, I don't think we're asking them to do the best, but we are asking them to do some oversight.
Well, wasn't the testimony in this case undisputed to the effect that there were no valid reasons to do a cancel or a no sale followed immediately by an X run?
No, there wasn't some legitimate reason such as a customer forgot to walk, therefore you would do a hedge run to cancel that out. There were legitimate reasons for edge run. Very rare I couldn't do that, but there were legitimate reasons. What we have here is that they were not, there's no clear evidence as to how it was ciphered out.
Counsel, I am a little concerned on the conspiracy, on the issue that appellant raises as to the conspiracy charge, that basically the evidence was insufficient to show the amount taken. Is that the crux of the argument? I'm concerned that that particular issue may not have been properly preserved, and here's why I say that. I'm looking at the trial transcript on page 290, and I'm looking at the portion of the transcript in which the motion for judgment of acquittal has been made. And defense counsel basically says, State failed to put on sufficient evidence to show that Minnie engaged in any conspiracy, any combination, any confederation, anything like that. But doesn't specifically say, oh, and there's also insufficient evidence of the amount taken. So my question for you is, has the particular issue that is raised on appeal relative to the conspiracy charge, was it properly preserved for review?
Yes, I want, because you have to prove that there was an associated offense to have a conspiracy.
So even though, at the time the motion was made, even though as to the grand theft charge, the argument was failed to prove the amount that she took, as to that charge, that particular argument wasn't made as to the conspiracy charge, but nonetheless, your position is that what you're arguing now on appeal has been preserved by that motion?
I would like to reserve that remaining time. Thank you.
If it may please the Court, Josh Heller on behalf of the State of Florida. As the Court seems to be aware of the case, and the only issue in this case relates to whether the trial court properly submitted to the jury a question of how much the defendant stole and how much her and her co-conspirators stole through the use of their cancel no-sale transaction, which was a specific scheme that I think that the Court appears to have a grasp of based on the questioning during appellant's questioning. I think we can address easily the second issue pretty quickly, which is the grand theft, which the value in that amount is $300. Jill Davis, the owner of the convenience store in this case, testified that on September 14th, 2006, the defendant was personally responsible for $381.17 between 7:28 a.m. and 10:54 a.m. on pages 82 to 83 of the record. The next day, the defendant was personally responsible for $168.18 from 6:50 to 9:28 a.m. That's also on page 78, 79.
I think that if I understand Ms. Wiggins' argument correctly, it is that it's true she testified to those things, but as a matter of fact, the procedures that she had in place would not permit her to determine with any accuracy whether, in fact, that money had been taken by the defendant.
Judge Webster, I think that the answer to that question really lies on a number of other portions of the testimony. First of all, Adam Flowers, one of the co-conspirators in this case, testified that on page 223 that any cancel no sale transaction was more than likely one of the theft transactions. So after admitting involvement in the crime, Ms. Davis put out a memo when she discovered this problem, and I think it was October or November, and when she discovered it and put out this memorandum that is actually one of the exhibits that's in front of the court, where she's basically pleading to her employees not to steal. And she said after she put out that memo, they came to a screeching halt on page 58, 59, and 87 of the transcript. The defendant, according to Mr. Flowers, when this memo went out, the defendant and her co-conspirators agreed not to steal any more via cancel no sale transactions because it was kind of figured out. Even if we were to take Mr. Flowers' testimony, and I think that this actually dovetails back into the conspiracy, that it's more than likely that a particular transaction is a theft transaction. In this case, Investigator Buchanan, based on the confirmed work schedule, and I'd like to address that the work schedules were in fact confirmed in a second, if I may, and a review of the register tapes, the defendant was personally responsible for $55,687 of theft. So if we take Mr. Flowers' testimony as, even though we're supposed to take things in the light most favorable to the state on JOA, but we were to say that it's more than likely, we'll say half, we've still exceeded $20,000 that the defendant is responsible for.
So, excuse me, is there evidence in the record that shows that $50,000 worth of, or however much it is, I think ultimately they determined it was $100,000 or somewhere around there, that $100,000 worth of inventory is gone? And there's no money to show that those items were actually paid for? I think that's the bottom line here.
As to whether or not, in other words, there's merchandise that's missing, et cetera. And I think that that goes to the nature of the scheme in this case, that was not going to be apparent. What was happening in these cases was that, is that as the transactions came in, the person would do the transaction, cancel it, and then no sale it and provide change. I don't know whether or not there's, so the inventory is going to appear the same because the transaction's still, I think, going to have that, and I don't even know if this was a register that necessarily included inventory per se. But one of the other things that they also did was there were gas amounts that were added back into this, and to keep the essentially the theft secret, because the state keeps track of gas numbers. So I don't know whether or not there's a method that they could determine necessarily inventory. I think that, possibly that's the reason that the theft scheme lasted for the length that it did, was because it was difficult for them to discover based on what they had available to them. But what we do know is that the vast majority of these transactions, or the transactions certainly are more than likely theft transactions, that the amount that was determined to encompass these transactions was, I believe the final count was $100,000 and around $200, which I think, Judge Wetherall, goes very well to what your question was. I think that's exactly what happened in this case. Certainly I might have a little more difficulty addressing this issue if we were talking about an over $100,000 theft conspiracy. But when we have $20,000 to $100,000, I think that the state's evidence is plainly sufficient.
So more than likely theft, more than likely is sufficient to sustain a conviction.
Well, Your Honor, I think that a co-conspirator saying more than likely is, and I think that the case law is clear that the testimony of a single witness, even when contradicted by other witnesses, is sufficient to avoid JOA. I think that I've cited that case in brief on that issue. But I think that you take that, you add that as well to the testimony that Ms. Davis provided, that she provided the actual hours worked and payroll summaries, and that was the issue I was addressing with regards to the schedule. There was some discussion, some mention in brief that the schedules were speculative and because they were prospective. But in this case, in order for Ms. Davis to provide her employees with insurance and other types of benefits, as well as to provide payroll, she actually hired a payroll company, a bookkeeper, and that information, according to Ms. Davis, Investigator Buchanan, and Investigator Herring at page 207, was provided to the officers when they were reviewing the amounts. So I think that we have basically the front end of what it looked like they were going to work, and then we have the back end of what the actual hours were that worked, and those were provided by the employees as they worked. So unless we're also going to say that they were lying about their hours too, it's pretty clear that the state's established sufficient evidence to provide both the grand theft, which is the $300 amount, and there's numerous places in the transaction where Jill Davis expressly stated that the defendant was the only one working or was working with someone who didn't like working the register, and that those amounts exceeded $300. I actually have written down those two that I mentioned earlier, as well as a March 11th, $369.23, and March 13th, $458.10. And then on page 268, Investigator Buchanan addressed numerous times in November in which the defendant was working alone where these transactions appeared, at least for part of the day, if not the whole portion of the time period. And quickly to address Rich and Strickland, in those particular cases, you're talking about, first of all, the amounts had to be certain. I think that, when we're talking about a theft case between $20,000 and $100,000, the state isn't required to establish that it's $40,000, 63 cents in order to establish, to move past judgment of acquittal. But irrespective of that, in both of those cases, we're talking about a restitution case where the amounts were certainly something that were rather speculative. The shrinkage from soybean.
Let me ask you a question about restitution, because
Sure.
I found that curious, and I know it doesn't directly play into the judgment of acquittal issue, but in this case, there was a restitution order entered for $30-some-odd thousand that, best I could tell, was either stipulated to that amount or was there a hearing on that, or how did they come up with that number?
Judge Wetherell, I don't know the answer to that question. It wasn't one of the issues that was raised on appeal, so I did not investigate it. But certainly, I can say that generally, sometimes the amount of restitution is agreed upon. Sometimes it's agreed upon. When it's not, sometimes there is a hearing to determine the amount, and the amount has to be determined by a preponderance of the evidence by the state, what the value is of restitution. And that's, I think, what these cases go to, is that value actually has to be determined. And when you're talking about soybean meal that's subject to environmental shrinkage, when you're talking about projected revenues of a restaurant, I think that's a very different circumstance than what we're talking about for judgment of acquittal. The fact that counsel made some reference to the fact that it was discovered 6 months after the fact, I really don't think that is a reason to avoid judgment of acquittal. If anything, I think that demonstrates the effectiveness of this particular scheme, that even Mr. Flowers indicated that when the memo came out it was kind of figured out, so they agreed to stop doing it. I think that the state has plainly demonstrated sufficiently for purposes of judgment of acquittal that the values in this case for both the conspiracy of $20,000 and the grand theft of $300 were plainly met, and accordingly respectfully request that this court affirm.
Thank you. Ms. Wiggins, you have about 1 minute and 40 seconds.
The standard is not more likely than not. The figure might be this, but the state has to prove beyond a reasonable doubt that the three cashier at the store that amount of money, and that was not established. Also, Your Honor, I will refer you to page 290, where the defense counsel said, as you grant that, and she made an argument as you grant that, the amount was bootstrapped. So she did address the amount of the grant that and the JOA. Now I will argue that it was preserved. Thank you.
Thank you. Thank you both. That concludes the calendar for this afternoon.